everyone, to Wolfstorth Rosenthal's continuing H-1B Toolkit for Employers webinar series. Today we're talking about initial assessments for employers and recruiters. My name is James Pinedo. I'm with WR's Knowledge Base team, and before we get started, we have a quick legal disclaimer. This does not constitute legal advice and is for informational purposes only. For legal opinions, please schedule a consult with one of our attorneys. We have a great team presenting to you all today. Ms. Julie A. Galvin has extensive experience advising a wide variety of clients, ranging from nonprofit organizations to multinational corporations, regarding all aspects of employment-based immigration. She's joined by Ms. Josune Aguirre Gamez, who has immigration experience, including assisting clients with employment-based immigrant and non-immigrant visa categories, as well as family-based immigration matters and removal defense. They have a great presentation. We'll let them take it from here. Julie.
Thanks, James. So we found that a lot of times recruiters and employers don't know what to do when they find somebody that they want to hire, but might need employment authorization in the United States. So we want to give this opportunity to provide an overview as to what issues to look for, let you know what you can and can't ask, and delve into some more complex issues. So to that end, Josune, say I have this great candidate. I'm looking for a business analyst. I found somebody, but it turns out they need sponsorship. What can I do? Are there certain things that I can ask? How should I start?
Great. So a lot of recruiters may already have this as part of their application process, but we received a great, guidance from the Deputy Special Counsel where he issued a memo and stated what type of questions were permissible, right? And so types of questions include, do you now or in the future require sponsorship to work legally for the company in the US? If so, are you currently in a period of occupational practical training, we short-term call OPT? If you're currently in OPT, are you eligible for a 24-month extension based on a degree in science, technology, engineering, or mathematics? And if you do require work sponsorship, but are not currently in OPT, will you be able to work for the US for at least 12 months? Now, these are permissible if we ask all employees these questions. Now, if you start to get into conversation with one of the candidates who have said yes to these questions, you want to avoid some vague or generic questions that may mislead or confuse the candidate, because that can lead into discrimination, right? We want to make sure that we don't defer or we don't, confuse the candidate where they would be reluctant to proceed with the process of the application.
That's great helpful information. So we can't ask general things like, where are you from, right? Or are you a US citizen?
Yeah, obviously if you're a US citizen, you would have work authorization, but that wouldn't be the smartest way to proceed with asking, somebody if they have work authorization. We want to make sure that we keep it pretty focused like these questions are, right?
Great.
Very focused to, do you require work authorization or sponsorship for work authorization? If so, these are some types of questions that may help you in determining whether, this candidate is viable for the company, because they would be able to work for the company for at least 12 plus months.
Okay, that's really helpful. So say I'm an employer and somebody does volunteer that they are on OPT. Would they have particular documents to show me? How would I be able to I-9 them?
Yeah, definitely. So the more common are these cards that these students may provide, right? A lot of students may come, ready to apply for the position as a business analyst, and they have what called an EAD, Employment Authorization Document. So they'll present an EAD, and you'll see that the category may be C03B or C03C, and it'll have the terms and conditions showing that it's post-op completion OPT, or sometimes it could be pre-completion OPT or STEM OPT. And you'll notice the STEM one is valid for 2 years, whereas the regular OPT is valid for 1 year. The less common one would be potentially an employee showing you an I-20, and on that second page of the I-20, you'll see that they've been approved by their school to work, and you'll see, employment authorizations, the periods, the type, and authorization dates. And at the time, if they're, applying, they'll show the current employer, right? And they would have to get permission from the school to add the new employer, so the new company.
Great.
Julie, are there other types of documents? So let's say it's not somebody who's in F1 status or a student.
Yes. So you might find somebody that is already in what's called H-1B status, which is one of the most common employment-based visas. And in that case, they would be able to transfer their H-1B visa to work for the new employer. So this document on the left that has an I-94 record at the bottom. So as you can see, it has a long number, which is redacted out right now, the name, the validity period, and the company name. They can only work for that sponsored employer. But if you see a candidate that has this, you can file in a petition to transfer them to work for your company. So that's really good to know. Now, H-1Bs are valid for only 6 years, generally up to 6 years in total. So this other document, it looks similar. So they're both called I-797 forms. The one on the left to get the H-1B approval. This is for the one on the right shows that it's a green card. So it's an I-140 approval. And this is also company specific, but if an employee has this or a candidate has this document, even if it's for a different company, that means they're at a certain point in the green card process where they're allowed to get extensions beyond that 6-year period, even if it's for your company. So that's very helpful because that means you're going to be able to keep them as an employee for much longer beyond the 6 years. So that's useful for your longer term planning.
Great. So if an employee comes, like this one shows that it's valid until 11/22/2023. Does that mean that they could potentially file a change of employer to at least 2023?
Correct. So if they don't have that I-140 petition, you would want to go back and see when they first entered into H-1B status. And then you can calculate out that the remaining time in 6 years. If they do have that I-140, you can go ahead and certainly ask for the full 3-year period. So it's 6 years total with a 3-year increments.
Great. So Julie, I know we discussed the H-1B a bit, but can you give us some basic considerations about it?
Sure, absolutely. So as I said, it's really the most common employment-based visa. So it's mostly for professional occupations, but really the H-1B is a little more specific than just general professional positions. It's for those positions that are considered to be specialty occupations. And to be specialty or specialized knowledge, you need to have a degree in a field that's very closely related to the position. So for example, a computer science degree for a software engineer, doctors, lawyers, accountants, something where there's a very close correlation between the degree field and the position.
Great. And so I know a lot of companies are private, so they would have to enroll in the lottery, right? So
Correct.
what does that mean?
So, and that's a great consideration. So if you're one of the lucky few that's either a university or affiliated with the university, you don't need to worry about this. But if you're a private company, there's a limited amount of H-1B visas. So there's 65,000 each fiscal year with an additional 20,000 set aside for those with at least a US master's degree. Now, as I said, it's for each fiscal year. So they're released on October 1st, which is the beginning of the government's fiscal year. And we can apply up to 6 months in advance traditionally. This year and the last year, the government has started a new process with an electronic registration period. So in order to get into that lottery, assuming we're going to have more applicants than we have visas available, and I would say for the last 8 years or so, traditionally we have, except for when there's been a very big downturn in the economy, you'll need to register in advance.
Great. So based on last year, they gave us a 90-day filing window. So that's kind of how we're, advising our clients right now on how to strategize for their potential candidates and also current employees as well who want to join the lottery, right?
Correct.
So going into kind of other basic considerations, if we have that business analyst and they have, an EAD that's valid until July 2021, there's, things to consider. So at this time, we have cap gap relief, and cap gap is only available upon filing the H-1B. So not once we get the electronic registration. I know last year that caused quite a bit of confusion, but we received guidance and they clarified that it's upon filing. So we would need to file, right? And so if we get the
Right.
90 days and we're, hopefully selected in March, or at least decided sometime in March or maybe early April, then we would know that we can file in those 90 days. So if OPT expires after the H-1B is filed, the school would then provide them cap gap relief, which would provide work authorization on that I-20 until September 30th of the year, because the H-1B is to begin on October 1st, the beginning of the fiscal year. If the OPT expires before filing, so let's say this business analyst, their OPT expires July 1st, 2021, and unfortunately the company is not able to file until August. So what happens to that candidate or employee?
Right. So that's going to be an issue for that employee. So one, they'll need to make sure in order to take advantage of that cap gap scenario, again, they would have to have filed timely prior to their expiration date in July. Now, last year there was a second round of selections and they came up in August. So if that was the case for this student, they would be fortunate enough to be selected for the lottery, but unfortunate enough where they wouldn't be able to take advantage of that cap gap relief. So in that case, they would have to look at other options. They can still file the H-1B. They could notify the consulate and depart if that's something that, barring COVID issues, is feasible to them. Another option is looking at another school program and getting that CPT that Josune had talked about earlier that would allow them continue to work. Obviously, timing can be an issue as far as when programming starts. But one thing, the important thing is to get your plan together as early as possible and for the employers to try to file as soon as they can in the filing window, bearing in mind that student's EAD end date. Last year, our filing window was for the first batch of cases was until June 30th. But if somebody's EAD expired June 10th, then it would be important to file that petition beforehand to make sure that they can take advantage of that cap gap.
Yeah, so that's important for recruiters, right? So if you find a really great candidate and you think an H-1B is viable and the company will support that H-1B, and you see that there's a July, 2021, end date for their OPT, to strategize and ensure, everyone involved understands that there's critical timeline for that employee if they want to ensure that the employee can continue working.
Absolutely, great points. And it's oftentimes you want to incorporate that into your offer. Make sure that the offer letter is accepted in time and that they're going to be able to start in time for that to take place.
Yeah, great. Also, something to note for recruiters is that sometimes USCIS does not allow us to file with premium processing for these cap cases. And we've had it where, USCIS has taken 9+ months to adjudicate a case, especially if we get an RFE that can delay the process. So even if you don't have an end date, you may want to think about filing as soon as you can to try to get ahead of that window.
Yeah, that's another really important point. As you mentioned, that it's only valid until September 30th. So that will allow the student to remain in the country, but their employment authorization unfortunately will end on September 30th. So
yeah,
very important to realize that.
So hopefully, premium processing is available. And if somebody gets into that situation, they can upgrade to premium processing when necessary.
Absolutely.
But what about prevailing wage and actual wage obligations? What should a recruiter know about that when it comes to
Sure, that's a really important obligation for H-1Bs. It's important to keep in mind that there is a minimum salary that will need to be paid. And the prevailing wage is what the government defines, the Department of Labor data defines as a normal wage for, depending on the job requirements for the position in a geographic area. We can also get private wage surveys if the government wage data doesn't fit. But if we don't find something that works, then the offer may need to be raised in order to meet that obligation. And also, for the actual wage issue, the company needs to pay in line with what it normally would pay for that position. So we can't be using the H-1B, obviously, to depress wages. Another issue that we often do see with H-1Bs are licensing requirements. So if the position requires a license, then the person must have that license at the time of filing. And if it's a position that would sometimes require a license, but it may not in this case. That could be feasible, but you'll need to be able to explain that to USCIS when you file. So for example, if it's a private or independent school that doesn't need a license, a teaching license for a teacher, you'll want to explain that and provide documentation of that, such as the state statute. If it's somebody that works like an apprentice, like an architect that works under somebody that has a license, a supervisor that has such a license, then you'll want to submit that documentation. And if the candidate has a provisional license, that should be sufficient if that's permitted in the state for that occupation, but they may get the H-1B limited to the end of that provisional license. So that's another important point when you're looking at planning. Other issues that we've often seen are degree and equivalency issues. Josune, can you talk about that a little more?
Yeah, so you discussed your business analyst candidate.
Yeah.
Now, let's say this business analyst has a degree in mathematics. That may not be a degree that would qualify for that position because the position would require a specialized knowledge in business analyst or as analyzing business. So that could be problematic. Also, what if this business analyst has a degree in business? Well, that's great. It seems to match, but that seems to be a big trigger for USCIS, and they like to request additional evidence when it comes to those cases because their standpoint is usually business is too broad of a degree, that it's not a specialized knowledge, but more so just kind of a general knowledge in degree in business. So that may not qualify as a specialty occupation degree for that position. Other issues are equivalency issues, but a lot of times agencies are able to work and look at, the foreign nationals transcripts and be able to provide a good equivalency when it comes to that. What about if the degree is not yet in the foreign nationals' hands? What happens there?
So in that case, they may still be able to apply for the H-1B if they can get proof from their university or college that they have completed all the degree requirements. So essentially, best evidence of that is a letter from the registrar certifying that. If it's somebody that has done everything but their thesis, then if they haven't met all their degree requirements, then that's going to be a problem and they're not going to be able to apply at that time. If they will have everything completed by the time they're able to file the case, then they can move forward with that letter. And we haven't seen that be an issue at all for USCIS.
Great. Now, it may be a little bit risky for a recruiter to recommend a master's H-1B cap if the degree is not, conferred yet, right?
Correct, right. So remember we have that pre-registration period, and while they have to have the degree in hand for filing, if it's not clear whether they in fact will have that degree in hand, we have to say at the time of the registration whether they'll be entering into the master's cap or not. So that would be an issue in case they don't get that degree. So I wouldn't suggest moving forward with a master's cap case unless they have that letter in hand or the diploma in hand.
Great. I think that's solid advice. Now, sometimes, I know you discussed if they had prior H-1B status because they're capped to 6 years. What if they had prior L1 status?
That's a really good question because a lot of people may not realize that while the H-1B is limited in length, so up to 6 years, the L1 also can cut into that H-1B time. So if somebody had been in the United States in L1 status, either L1B or L1A, that any time spent in that status will be subtracted. So that can impact your ability to keep this person on longer term.
Yeah. And so we talked about requests for evidence and about degrees not matching, but sometimes there's positions that may trigger that, right? So we have had analysts that were scrutinized at a higher level, but also sales related roles and sometimes just general managers as well, right?
And yeah, exactly. So my business analyst might be a problem because analysts can be highly scrutinized. So we'd really have to look closely at that degree and try to make the case that it's very closely related and is specialized enough, tying it together with his job duties in that role.
Great. Great. Now, what if this business analyst has a level 1 wage? Is there anything that we need to be concerned about?
So the last couple of years, this has become an issue where USCIS has been issuing requests for evidence questioning a level 1 wage and whether a level 1 wage really shows that if somebody's paid at that entry level, whether they are in fact have that specialized knowledge, rising it to the level of an H-1B visa. Legally, there's not a strong basis for this, and I think across the board, most law firms have been successful in combating it, but it still could crop up every so often. I think we did get an RFE on this issue recently, so it still is something to be aware of, that it can be questioned if you're going to come in at an entry level.
Yeah, great. So we talked about this business analyst, we talked about the business degree. What about liberal arts? Could that be potentially a triggering, RFE for USCIS?
It sure can. I think liberal arts obviously is very broad, and a lot of jobs that just require even just a bachelor's degree without specification would be a problem. Liberal arts degrees, unless it's an English teacher or something where we can make the case that there's a very strict correlation, liberal arts degrees may also be an issue. And back to your management and sales examples, I think those are a lot of occupations where somebody might just have a liberal arts degree and are perfectly qualified for the position, but maybe not perfectly qualified for an H-1B visa.
Yeah, well said.
Yeah.
So other considerations are, how much time does this foreign national have for the lottery, right? So if we only have one chance, that may be a little bit, too tight for an employer. Maybe they prefer to have somebody who has those 3 years or at least 2 years, so they can ensure that they have at least 2 chances for that lottery. Sometimes we also have the issue of the foreign national having CPT after they had OPT. And what we've seen with that is that USCIS tends to scrutinize that a little bit higher to say whether the foreign national was maintaining their F1 status. So although everything seems kosher, they have this I-20 that shows that they have work authorization, their school approved it. Sometimes USCIS will take issue to it because they'll say either it's not a requirement for the degree and that's not permissible, or that they're going in the same level. So if they've received a bachelor's degree, they have OPT, then they went into a new program to receive another bachelor's degree in CPT, sometimes USCIS will take issue. Now, we've been successful in arguing that it is a requirement for the degree, but you'll want to have the cooperation of the school, obviously, and get another letter from the registrar confirming that it is a requirement. Otherwise, the H-1B may be approved, but may require the foreign national to travel abroad and obtain that visa before they can enter an H-1B status.
Right, we've seen that as well. So another good point to be aware of.
Yeah. All righty. Well, thank you for joining. We really enjoyed this, and we hope that you're enjoying the H-1B Toolbox. If you have any questions, or if you have questions regarding, candidate assessment, we'd be thrilled to help you. Here's our contact information, so please feel free to contact either of us. Thank you.
Thank you.